constitution mandates this. Parliament does something, your lordship say, no, sorry, this is not good enough, go back. It's happened to, that's what is happening between the substance of the law which your lordships are declaring and the procedure the parliament is adopting and not following it. Two members of the executive, the prime minister and a member of his union cabinet. The majority control stays with the executive. But if you do it, that will violate the basic structure of free and fair election. This is recognized in multiple judgments. So leave alone a law, it can't even be done through a constitutional amendment. Election Commission with all its powers is much more consequential than a private dispute between any two parties can ever be. The protections at the stage of during the tenure and from removal are only part of it. And that's what Dr. Ambedkar also said. This case is a far more direct challenge and a far more classic and conventional challenge than Anoop Barnwal was, of course, a case which, and that's what it was the questions which were posed by my lords to us yesterday and today. What really did Anoop Barnwal say? So that was a case where there was a gap. Was there not a gap? How did the court fill the gap? Those were the questions. Plus, first, this case is a classic challenge to Section 7 and 8 on the basis that it's unconstitutional. We are not on competence. Then what remains violation of provisions of the Constitution. So that's the classic challenge is what it is. The relevance of Anoop Barnwal is this. Anoop Barnwal, in my respectful submission, did two things. Firstly, it framed a substantive rule of constitutional law. This is not the first time, as many learned counsels before me have pointed out, that the to and fro between this court and the legislature and the parliament has happened on the question of whether the substantive requirement of law is being met or not. Your lordships have in other contexts also sent it, saying substance, constitution mandates this. Parliament does something, your lordships say, no, sorry, this is not good enough, go back. That's what is happening between the substance of the law which your lordships are declaring and the procedure the parliament is adopting and not following it. That's exactly the situation here as well. So it's nothing new. And your lordships have corrected multiple times. Now, my first submission I have already placed, and in that context, your lordships, as to the mechanism of appointment of CEC and ECs, a substantive rule of constitutional law is the first thing Anoop Barnwal did. Second, it said that the procedure for following that constitutional substantive rule is through a law of parliament. And third, it said that till the time parliament comes up with a law to follow that rule, here is the interim arrangement, which is the CJI, the Prime Minister and the LOP. If we look at Anoop Barnwal in this fashion, and my learned friend Mr. Bhushan read out those paras, 306, 309, 311, 297. They are very clear that non-executive dominant selection committee is the core substantive constitutional rule. Now, once that rule is there, what does it do, Malats? It sets a bar. Anoop Barnwal sets a constitutional bar. It says, below that line, whatever you do, the legislature you can do. You can come up with A, B, C, D, E, F. But you can't cross that constitutional bar. What they have done by the procedure of law is exactly that. Plus, the law, in fact, breaches the main rule itself, the substantive rule, which is two members of the executive, the prime minister and a member of his union cabinet. The majority control stays with the executive. So you can't use the procedure, which is the law, to breach the substantive condition of the constitution. My lords will have article 324 for a moment, just the article itself, 324(2). And that will also make it clear, because that's a question which your lordships have repeatedly posed to us from yesterday. Article 324(2), which is relevant here. The Election Commission shall consist of the Chief Election Commissioner and such other number of the Election Commissioners, if any, as the President may from time to time fix, and the appointment of the CEC and other ECs shall, subject to the provisions of any law made in that behalf by Parliament, be made by the President. So, the power by the Constitution itself was with the President, subject of course to a law. But 324(2), without a law, gave the power to the President. If that power itself has been read down in Anoop Barnwal to mean that it cannot be through executive dominance, plus where is the question of a law doing the same thing? I hope I'm making myself clear. The power came directly from the Constitution. Under 324 clause 2, the power came directly to the president from the Constitution. It was a pure executive power. So when absent a law, this court has said in a constitution bench that even a constitutional source is not sufficient to give pure independent power, because when we read constitution as a whole, the demand of the constitution is that the CEC must be appointed through an independent process. If that constitutional source, and that's why I said, no, that's the substantive constitutional rule which Anoop Barnwal and fixes. It's like this. I'll give another example. The classic our basic structure doctrine. Procedure of basic structure, there were procedural limitations in Article 368. Two-third majority, present in voting, state approval. Those were all procedural requirements. There was nothing of substance in the Constitution. The basic structure doctrine is a value-based doctrine developed by this court from the Constitution, saying no, procedural requirements are not sufficient even for a constitutional amendment. There are value-based substantive limitations on the power. So what Anoop Barnwal does is, it puts substantive limitations on the mechanism of appointment. And you can't breach it even through a constitutional amendment. I pitch it higher than Mr. Shankar Narayan did yesterday. Mr. Shankar Narayan said you could possibly have done it through a constitutional amendment process. But if you do it, that will violate the basic structure of free and fair elections. It's recognized in multiple judgments. So leave alone a law, it can't even be done through a constitutional amendment. Because by laws, we'll see the power came from the Constitution itself. So, there are many instances where lordships point out a procedural defect and a substantive defect. What the parliament does is, it will just bring in a law, but if the substantive defect remains uncured, sorry, go back again. It's not the first time we are asking lordships to do it. In different contexts, my lords have done it multiple times. Now, this judgment my lords will have in my compilation. This is what is happening. Your lordships in substance said can't be executive dominant. Bring a law. And they bring now a law which violates the core principle. That can't be. So, that's point one. Roger Matthew line is my next point, which I have already in place, so I'm skipping that. Because even Mr. Parekh plays the latest judgment, 2026 Justice Govt. That's also covers, in fact, what is the scope which the Supreme Court has settled. That has been read out already. Then we come to a bunch of independent arguments, primarily, and Mr. Bhushan has covered it partly, but I'll just extrapolate. In arbitration cases, my lords are aware, for the longest time, and this was more endemic in PSUs, etc. But it used to be that unilateral clauses were permitted. And what the effect of that was, that of course, if I can use a cricketing analogy, you would have a home umpire. It was akin to having a home umpire. You would have really a person who was at a minimum sympathetic to your cause. And the outcomes, I will place the judgment, one more judgment, which Mr. Bhushan placed the Constitution bench, which was the second one. There's the earlier judgment of Perking Eastman. I want to place that. I'll straight away come to your lordships will grant me some leeway. Just 30 seconds I'll come to that. So, in 2019, Perking Eastman is the first judgment. The Constitution bench is the second judgment. In Perking Eastman, I have extracted it, so my lords may take it from my written submission at page 7. Yes, correct. I will not take your lordship through the compilation then. Cases where both parties could nominate respective arbitrators of their choice were found to be completely different situation. The reason is clear that whatever advantage a party may derive by nominating an arbitrator of its choice would get counterbalanced by equal power with the other party. But in a case where only one party has a right to appoint a sole arbitrator, his choice will always have an element of exclusivity in determining or charting the course of the dispute resolution. Naturally, the person who has an interest in the outcome or decision of the dispute must not have the power to appoint the sole arbitrator. So, presence, if it's a 3-member panel, is fine. Dominance is not. It's the same principle. Presence is fine, but dominance is not. If you can determine who it will be, there is a problem. If you are one of the many who's making a decision, that's all right. That's exactly the principle which applies here. And next is, of course, Mr. Bhushan has placed that in the context of arbitration clauses itself, it was held violative of Article 14. I need not labor the point that Election Commission with all its powers is much more consequential than a private dispute between any two parties can ever be. For not just for the future of the republic, if I can say that, and future of democracy. Now, if that is the principle even in private law, it will apply with even more force, in public law, and certainly in the context of Election Commission. Just allow me to labor this a little bit. Election Commission has multiple functions. I was thinking about it. There are very few institutions, maybe with the exception of the Supreme Court, which has such wide-ranging functions. It allocates symbols. It announces elections. It actually suggests disqualification to the president and to the governor of individual members, which is quasi-judicial. It also, after announcement of election, literally runs the government. So, Malas, if the commission goes haywire, then in that sense, or if there's a lack of independence in that institution, the entire democratic republic is at stake. And Malas, I'm not at all overpitching a point, Malas. I sincerely believe that it's essential that, Malas, we have an independent commission, and that's why my lords in Barnwal have repeatedly said that the protections at the stage of during the tenure and from removal are only part of it. And that's what Dr. Ambedkar also said. But if the appointment process itself is not proper and you have a person who is not independent, then the second and third layer of protection is no use. And Malas, it's appointment which the government wants to hit. So, Malas, in some constitutions, Malas, what election commission is in the nature of what is called a guarantor institution. Malas, for instance, in the South African constitution, it has been, their election commission has been under, there have 3 or 4 bodies, including a prosecutor body, which is under a separate head. So, Malas, it is in that sense, Malas, a double-layered protection. And what is implicit in our constitution, which is that election commission is a guarantor institution. We don't say it, they say it because it's a later constitution. They have the benefit of experience. But the same principles apply. And Malas, just one emphasis I'll say, Malas, free and fair are words we use commonly together. Malas, they have slightly different meanings. Malas, election can be free, but without being fair. Malas, that is also possible. And sometimes, Malas, it can be fair, but it may not be free. Both are, Malas, slightly independent things. Malas, if the rules of the game are placed in such a manner that they're tilted, if the umpire, Malas, if it was a bias, game seemingly will be fair, but no balls will not be given no balls, wides will be made regulars. Malas, I'm just using a cricketing analogy. So the rules. Malas, that's. Malas,
Don't know much about it.
Malas, your lordships will be, even in India, your lordships have to be aware of it somehow.
You're questioning the decisions of all umpires prior to introduction of neutral umpires.
Plus, there would be good decisions as well in that, Malas. There would be good decisions. But on balance, the chance of a bad decision was way higher.
Basics you certainly improved.
Yes.